That's why I wanted one, so. Thank you.
Good morning, Your Honor.
Okay,
We do have a sign-in sheet, Judge. You want me
thank
to
you.
approach?
Yeah. Can y'all hear me in the back of the courtroom? Thank you, sir. Thank you. Okay, go ahead.
Thank you, Your Honor. Okay. Our prosecutor isn't here yet, so that works. May it please the Court, Your Honor, Brad Stewart, present, Judge. My first client on the court's docket is Mr. Dean Cook, Judge. This is 22 CF 803.
Okay,
Mr. Cook is present and approaching.
all right.
And, Your Honor, we are before the court with regards to a status on his conditional release plan. Judge, the order was signed February 27, 2023, and as part of that release plan, it calls for placement in a group home. He does live with his mom temporarily. The order establishes that. Problem is that his mother was the victim in the underlying charge. And I did include in the order that his placement was to be done as expeditiously as possible. That is important and critical based on the nature of his intellectual disability and the underlying crime. That has not been done at this point, Judge. I would like to, if we can, leave this on for a status within the next 30 days to ensure we don't lose track of this and Mr. Dean does, Mr. Cook gets the help that he needs.
Who's the prosecutor on it?
It's me, Your Honor.
Any objection?
No, no objection.
All right. Okay, we'll do the best we can. So let's see. Let me get my court dates. What do you want to do? Like a miscellaneous, say November 2nd? Is
That'll work, Judge.
that okay, Miss? Leon?
Yes, Your Honor.
Okay. All right.
Is that the second or 22nd, Judge?
Second.
Second, thank you. Very good.
Okay, thank you.
Your Honor, my next client is Mr. John Harvard. Mr. Harvard is an inmate, and as he approaches, Your Honor, we are on the court's docket for purposes of our motion to dismiss count 3 based on double jeopardy principles. I don't believe the state has objection to that.
No, Your Honor. Count 3, just for the record, is possession of a firearm during the commission of a felony. The state will dismiss that based on defendant's motion to dismiss.
All right. Does that change guidelines, numbers, and
It would change the score sheet, Your Honor.
is there a deal or a plea or anything as a result
This
of
case was set for trial. He filed demand for speedy trial. So he's facing a 3-year minimum mandatory for possession of a firearm by convicted felon.
You want to see if you can, you want to waive speedy and see if you can work out something as a result of this dismissal?
Judge, we're on for the 4th. We're on for Tuesday.
Okay.
And I anticipate...
If not, we'll go to trial. If you can't work it out, okay.
Yes, Your Honor, and I anticipate speaking with Mr. Harvard both today and over the weekend with regards to
You mean
trial
the 5th.
strategies,
We're on for the
opportunities for
5th.
plea.
The 5th.
5th, I'm sorry, 5th.
Yeah.
My
Okay, well,
apologies.
if he wants a trial, we'll give him a trial, or if he can work out a deal, very good,
Yes, Your Honor.
based on this dismissal. Okay? Okay, thank you.
Thank you.
See you at 12.
Yeah. See you this afternoon.
Okay.
Your Honor, I do have one other matter on the docket. I don't believe that he's an inmate. That's Oakley Kimbrell. I don't believe he's present. I am covering for Mr. Tim Shaw, Judge. He has one matter on the docket, Robert Scott Whitehead. We do need a control date on that. If we can have next
Thursday is fine, Your Honor.
Thursday.
That's a VOP, isn't it?
Yes, Your Honor.
September 5th. Is that right? Is that,
7th.
is it that? 7th. I'm sorry, September 7th.
Very good. Thank you, Your Honor. He's not here.
Yeah. Okay.
Is Mr. Mobley ready for the fingerprint exemplar? Your Honor, could we call Dusty Mobley? He's here for a motion for fingerprint exemplars. I do have someone from the sheriff's office here for the fingerprints.
All right. Is there a problem with that, Mr. Williams?
Judge, there's no legal objection I can make to it. It's not invasive, so.
Not.
And when Mr. Mobley's brought up, would Your Honor mind if the sheriff's office up and did the fingerprints over here? Okay.
Can we just go ahead and take another case?
And Your Honor, I do have an order,
I believe he's walking through the,
an order granting the state's.
hey, Mr. Mobley, come over, stand over by me for just, for the initial part of it. Your next time to come back is Monday the 5th. Yeah.
All right, who next? Let me see, Miss Dudley?
I got the case Drake and 21 CF 752. We're here for a motion to set bond.
Drake, let me, you know what page he's on?
No, sir, I don't.
Jarquez Drake, okay. What's his current bond?
No bond. It's a violation of probation, Your Honor.
What says the state?
1 second, Your Honor, I apologize. May I make argument, Your Honor? The state is objecting to defendant's bond motion for several reasons. Defendant was on probation, as we know, in 21 CF 752 for sale, manufacture, deliver controlled substance, resisting without violence, possession of paraphernalia, and driving while license suspended. Then he committed a new law violation, and he was charged with trafficking in fentanyl, sale, manufacture, deliver cocaine, sale, manufacture, deliver methamphetamine, possession of controlled substance, and resisting without violence. This arrest was the result of a thorough investigation. The Sheriff's Department established surveillance on the defendant on several occasions. They noticed short-term traffic, indicative of sale of drugs. Additionally, the evidence present shows that there was a lot of information coming from citizens and cooperating defendants. Through a phone download, it was discovered, text messages were discovered, indicative again of drug transactions. A search warrant was executed. At the time of the search warrant, the defendant was in the house along with these 2 minor children. He was seen, observed by law enforcement as they broke into the house, reaching into the cabinet of the kitchen, where they eventually found approximately 32 grams of fentanyl.
I think I'm gonna leave the bond with no bond.
Thank you.
Your Honor, next one I have is Andrew Richards. and 21 CF 1207, and 22 CF 138. I do have a plea. Your Honor, if I may approach?
All right. All right, you're Andrew Richards, sir?
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God?
Yes, sir.
You want to admit that you violated probation, is that correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Did anyone force you or threaten you to enter this admission?
No, sir.
Are you happy with the work Ms. Dudley has done for you on your case?
Yes, sir, I am.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Court finds the admission freely and voluntarily entered. Court accepts it. Adjudicates you guilt. $100 cost of prosecution per case. 12.1 month Department of Corrections. With credit for time served, the 12.1 is to run concurrent on all cases, all charges, and all costs to judgment, adjudicated guilty on both cases, all counts. Okay? How much time have you served?
If I'm not mistaken, I think it's still around 9.5, 10 months.
You've already served in jail 9.5, 10 months?
On all cases, yes, sir.
Well, you'll probably get down there and be released very quickly, so stay out of trouble.
Yes, sir, thank you.
That's another condition of this sentence is you stay out of trouble, okay?
Yes, sir. Thank you.
Yes, sir. Your Honor, that's all I have.
All right. Ms. Reed?
Good morning, Judge. I am covering for Mike Gates, and that is for Antonio Betancourt,
Okay.
23 CF 820. And he's also represented by Mr. Gibbs with the Public Defender's Office.
Yes, Judge. Tim Gibbs, also for Mr. Betancourt. I have him on 23 CF 116.
And, Your Honor, we are here, there has been a confidential mental health report filed, basically determining that Mr. Betancourt is not competent to proceed, and I believe the parties stipulate to that report coming into evidence, the court considering that report as well as making its own findings
Yeah, I
of the
did.
defendant's competency.
I have to make those findings.
And then, so Judge, all I have is an order adjudging Mr. Betancourt not competent to proceed and committing him to Department of Children and Families, Florida State Hospital. May I approach?
All right.
Okay.
And a digital order, Judge, that I can send to the board.
In addition, different from this one?
I have, it's one from my case, Judge, because I represent
Oh,
him.
okay. Yeah, yeah.
I can send that through the portal.
All right, yes.
Thank you, Judge. I'll send that now.
All right, Mr. Betancourt. So you're going to be going and getting some help, okay? Okay.
All right,
Okay,
thanks.
thank you, Judge. And that concludes my business before the court. May I be excused?
Yes.
Thank you.
Mr. LaPella? Morning.
For the record, Sean Lopella, representing Robert Needner on 22 CF 977. This is a motion to clarify sentence. Basically, Your Honor, it's fairly straightforward. March 6th, my client entered a plea, was put on 5 years probation. In the plea agreement, it indicated that a special condition of his probation was to have no unsupervised contact with minors other than his own children.
Get that microphone a little closer
Sorry.
to you. All right, yeah, no unsupervised with minor children.
Yeah, with his, other than his own children. The court, it was Judge Flowers at the time was on the bench. He reiterated basically verbatim what was in the plea agreement as in the oral pronouncement of the record. However, when we got the probation order back, it said no contact with minor children other than his bio children. And the unsupervised part is a pretty important aspect of it. We'd like the court to enter an order basically correcting that part of his sentence and adding the unsupervised language in there as a condition of the agreement, and then moving forward.
The state has no objection, or that was the intent of the agreement.
All right, send me an amended judgment and sentence.
All right. And I would just ask that probation
Or I'll,
follow the oral pronouncement.
It's changed. Get something in writing. We
I will put it in an order, Judge, but I just want to make it clear that the default of probation shouldn't be no contact. It should be following the plea agreement, because it was a big hassle to do this. So that's all I'll say about that.
Mr. Berry gave you a hassle? That's hard to believe. That's hard to believe.
It wasn't his case, I don't believe, Judge.
Don't give Mr. LaPella a hassle if you don't. Okay, thank you.
If Mr. LaPella had a call this week, could have probably taken care of
We
this.
did. I'll talk to you about it later.
Okay. They didn't
Thank
call
you.
me.
All right, that's all I have, Judge. Thank you.
All right, thank you. Mr. Stewart, you got other cases, or?
I do have one, Judge.
All right, Ms. Flowers? Okay.
We're just waiting on the state. Good morning, Your Honor. Jennifer Flowers for Shane Hunter. We're here on a VOP. We have an agreed upon sentence with the state.
All right. Mr. Hunter, you're Shane Hunter. Would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God? You swear the testimony you give for is course of truth, so help you God?
Yes, sir.
Okay.
The only thing is, so it's 9 months jail. You have to complete the Emerald Coast.
Say only 60 days.
That's somebody else's. And Your Honor, we've previously gone over the terms of this plea agreement. He's just signing really quick. And may I approach with the plea?
I just did.
Mr. Hunter, you want to admit that you violated probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Do you understand the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission?
Sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Yes, sir.
Are you happy with the work Ms. Flowers has done for you on your case?
Yes, sir.
Court finds admissions freely and voluntarily entered. Court accepts it, adjudicates you guilty. 9 months jail with credit for time served from April 9th, 2023. Court revokes and terminates probation, waive non-monetary, monetary to collections, $100 VOP fee, $150 cost of defense, complete Emerald Coast Life Center program while in jail, and adjudicated guilty. Okay? Thank you.
Yep.
All right.
Next, I have Mr. Gregory Lamar Siegel in 23 CF 1727. We've entered into a plea agreement with the state. He just needs, and we've previously gone over the plea. He's just going to sign.
Mr. Siegel, you're a Gregory Siegel.
Yes, sir.
Would you raise your right hand to be sworn, please? You swear the testimony you give for is course of truth, so help you God?
Yes, sir.
You want to enter a no contest plea to the charge of burglary of an unoccupied structure, correct? A third-degree felony? You understand that? Did you read and sign this plea and sentencing agreement form? You understand the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Flowers has done for you on your case?
Completely.
Court finds the plea is freely and voluntarily entered, or the plea. Court accepts the plea, judge you guilty, 60 days jail with credit for time served, $515 court costs, $150 cost of defense, all monies to collections, and court reserves on restitution for, what, 90 days?
90 days is
90 days. Okay? Thank you.
Thank you, Your Honor. That's all I have. May I be excused?
Yes.
Well, everybody that I've got for this morning is in jail. So if you've got the jail folks here, we can start with mine.
We don't have any out of custody?
I'm ready, yes.
Don't we, who we have out in the audience? Anybody here that's on a case?
I have someone out here, if I may approach for a second. He handed me this, and I don't know if he's in the right spot.
I take it they're not all here.
Let the public defenders look at this.
Satisfaction of lien stuff also. It's a CF case, but I don't know why we're doing it right here.
Somehow, what's his name?
Tommy Griffith.
He got a notice to appear up here on some civil lien. We have no idea what it's about.
Judge, I've been handed copies of says satisfaction of lien. I take it as a release and satisfaction. Was he required as a condition of supervision or something?
I'm gonna hand it to the clerk and she can check.
Your Honor, if I may, I can give you some insight on this. These were judgments of liens that were placed on my property that I took care of. Recently, there was an ad run in the bulletin saying that the court owed me money in return. So when I came here to find out what it was about, on these liens, when I paid the liens, I had to pay them to the court. The people were deceased. So I don't know what the deal is, why I'm really here today. They were saying you file here and you get your money back.
This just sounds like a civil matter.
I don't even want the money back. It was, I wanted to go to the people that I owed it to. Unfortunately, they're deceased. So I paid it to the clerk and got the release of lien.
Why did probation do an order to appear for today?
I didn't. Tommy's been off probation for years.
Well, is he due any money back? Is there just some money in the registry or something? So your court costs are still outstanding?
My court costs are? So there shouldn't be any outstanding fees. Of course, I'm not arguing this. If there are, I'll pay them.
Are the liens still in place right now?
I've got the satisfaction of judging the liens right there.
So you're trying to get the money back?
There was an ad run in the bulletin. No, I'm not. Ad run in the bulletin saying that the state owed me money back. So when I came here to the courthouse to find out what is this about, and it came up to these,
Hang on one second.
What is your name?
Tommy David Griffith Jr.
I can't see it.
That's fine.
Okay, this was, you are Tommy, Tommy,
David Griffith Jr.
all right. And the notice he got was under this case number?
Yeah, this says
Yeah. And your first name is?
Tommy.
Tommy?
Yes, sir.
You need to change your name to Tommy, not that Griffin person, okay? Because they gave you someone else's notice, okay? You're good, all right? Thank you, okay.
No.
I don't want to give anybody out
Yeah.
of custody. What's your name, man? Desiree, you were supposed to be in court last week.
Judge, Ms. Lige, actually, I say last week, day before yesterday, Ms. Lige was on the docket for Monday. Habeas for.
What's her
She's
name?
Present in court. Desiree Lige. Desiree, come on out and spell your first name.
Lige.
Your first name, ma'am. I've got.
Desiree.
Your Honor, just briefly, I have Miss Lige's mother on supervision, and
Yes, sir.
when Desiree didn't show up the other day, I reached out to her mother and told her, hey, if you can get your daughter up here this morning, she can address the court for not showing up on Monday. Here she is.
Okay, I'm trying to find her on the docket.
I don't believe she'll be on the docket.
She won't be on today's
She failed
docket.
to appear on Monday. I just
all right.
told her to be here today.
Why did you not show up last week?
Yes, sir. I was unaware that I had court. I've moved address. I've changed addresses.
Your Honor, I'm sorry. Ms. Lige has a habit of showing up early whenever she wants to. She has a habit of missing court dates, and she always seems to be unaware of them, even if she's noticed in court. So we would object to the court withdrawing the case.
Judge, she is a dialysis patient, and I know in the past, that's been one of the issues with her being in, is she would be in dialysis. So I'm not, I don't really have anything else to add. Does your medication affect your memory? She's indicating that
What's she charged with?
Judge, it's I'm sorry, go ahead.
Child abuse, Your Honor.
It's without great bodily harm.
Without?
Yes, sir.
The case has been around for a while because she has a habit of just not showing up, unfortunately.
If she's jailed, Judge, the jail's going to have to be responsible for getting her to dialysis. It's not a situation where they can wait a month and let her be.
If she failed to show up next time without really good reason, it's going to be a no bond.
Yes, sir.
So I'll recall the capias this time.
All right.
For the record, what's the court date so Ms. Lige is available? Available and aware of it?
Judge, set us for October 30th.
October 30th.
Yes, sir.
9 o'clock.
I understand.
It's the day before Halloween, so it should be easy to remember, and you'll get a piece of paper, I guess, from the clerk.
Yes, sir.
Sticky on your
We're going to print you one right now.
Okay, thank you.
Hang on. Okay, next one.
Judge, everybody else that I have is incarcerated. I believe everybody else in Ms. Rivers has. Mr. Gibbs, do you have anybody who's not incarcerated?
I have an out of custody judge.
Mr. Gill.
Your Honor, I have Ms. Tony Anderson. Your Honor, Ms. Anderson is here for 23 CF 1240. Judge, I think we're still actually kind of waiting on confirmation of if we can resolve this today.
Yes, Your Honor, the offer would be to reinstate
the VOP today. I don't have that written up. If the court would prefer that be written up, I can certainly write that. 23 CF 1240.
Ms. Anderson, would you raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God?
Yes, sir.
You want to admit that you violated probation?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
You want to force you or threaten you to enter it?
No, sir.
Admission? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the admission freely and voluntarily entered. Court accepts it. Will reinstate probation original terms.
Thank you, sir.
Thank you, Judge.
Your Honor, I will file the score sheet within 5 minutes.
Okay.
Oh, you need to see Ms. Yeah, you need to see probation. Otherwise, Judge, this morning, I believe I just have inmates. Do you have any other? I know there's a few pro se as well, Judge.
Sir, your name is?
Weir, W-E-I-H-E-R.
What's your first name?
Your Honor, I represent him on one of his cases. They appointed me to represent him on one, but not all. So we would be seeking appointment for
All
all of
right,
his
I'll
cases.
appoint you on all the cases. When's his next court date? October 30th or something?
Your Honor, we would ask to have his case put on for October 30th.
October 30th. Thank you. Thank you, sir.
I'll be out to see you, okay?
All right, next, Mr. Gibbs.
This is Mr. Stewart's client, Judge.
Yes, Your Honor. May it please the court, Brad Stewart on behalf of Oakley Kimbrough. Judge, this is 17 CF 767 and 18 CF 2089. We're before the court with regards to violation of probation. We did file a bond motion, Judge. We're going to withdraw that at this point. And from a scheduling standpoint, we need to go ahead and schedule this for a evidentiary hearing.
You all have any idea when you want the hearing?
Does the court have any dates in the beginning of October, Judge?
About October 5th.
October 5? Very good.
Okay, how about that? Okay, thank you. Thank you, sir.
Thank you, Your Honor. Judge, that's all I have for today. May I be excused?
Okay, yeah.
Thank you.
Judge, I spoke with a Mr. Eric Allen earlier. He's a pro se person out of custody. If the court wanted to address his case.
All right, come on up. Eric Wayne Allen? Okay. You are here, is this a VOP arraignment?
Yes. Yes, Your Honor.
Is there an offer from the state?
This is Miss Leone's case, Your Honor.
Okay, let's see what they have to offer. Okay.
I just need a little bit more time.
When you tell a judge you need time, that might mean something you don't.
Not that kind of time.
We can continue, Your Honor, to give him time to, how long would he need? How long would you
Complete the
need?
terms of probation?
1 month?
6 months.
6 months?
Yes. It was only 6 months to begin with, so. I was even told I didn't have enough time when I started it.
What is it, some type of financial?
Yes, yes, sir, right now.
How much?
Well, my work got real slow, so I've done a lot of I'm almost done with my hours. I have like 30 minutes left on my hours. But work got slow, so I couldn't, pay for the classes I needed to take. So all I need is that, and I'll be done.
Gotta take some classes.
The recommendation from probation, Your Honor, is revoke and terminate an incarceration, but
Your Honor, can I inquire of it?
Yeah.
What do you have to do?
I just have to have my family is on the 12th, the Mother's Against Crime.
Okay, he didn't complete DUI school, Judge, and if he unsuccessfully terminates that, it's going to affect his driving privileges for a while. If we can continue his case for we don't want to get it that long.
Okay, well,
If we could continue it for 2 months, maybe he can have the stuff done.
I'll do my best.
He can come back and we can see where he's at then. And
I'll continue it to November 9th.
Yes, Your Honor.
Okay? Continue, set his case on November 9th.
okay, and then I'll try to tell him.
If you're halfway through your class or whatever, you're making progress, good. If you ain't done anything, then
Yes, Your Honor. Thank you.
you were asking for more time, you may get it. God, I've got every time I mow the yard.
Your Honor, Tim Gibbs on behalf of Harriet Ash. Sorry, Judge, let me pull her case back up.
I got it. No. Harriet Ash, VOP.
Yes, Judge. Managed to slip off my ever so trusty list that I typically use. Judge, this is case number 21 CF 2408, confirming if there, does the state have an offer on this case? I believe there was one that was sent.
How do you spell the last name, Mr. Gibb?
Ash, A-S-H.
Oh, Ash, sorry, yeah, no, it's mine. I thought it was an H.
Judge, we'd like to go ahead and just enter denial today. I see the state's offer. It's calling for DOC time. I'd like to have a moment to speak with her about this. If we could just put her for next week on the 7th, I think I can speak with her.
September 7th.
Thank you, Judge.
Thank you.
Yeah, I'm going to come see you probably next week, and we can talk about it. Your Honor, Tim Gibbs on behalf of Wesley Beitler. This is 23 CF 1642, 22 CF 1413, 21 CF 229. Judge, we're working on referrals to inpatient treatment options, so we'd like to enter a not guilty plea and denials across the board. If we could leave this set for September 26th for a status, I think we might be able to get it wrapped up.
All right, September 26th.
Thank you, Judge.
September 26th?
Yes.
Oh, yes.
We'll see if we can do it. Go ahead. Yeah. Your Honor, Tim Gibbs on behalf of Ryan Bielik. This is 22 CF 1477, 22 CF 2278. Judge, I believe we've reached an agreement. He just needs to sign the written plea agreement, Judge. If I may approach, Judge.
Are you Ryan Bielik?
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for his course of truth, so help you God?
Yes, sir.
All right. Excuse me. This is 22 CF 1477, 22 CF 2278. State of Florida versus Ryan Bielik. You want to admit that you violated probation?
Yes, sir.
Did you read and sign the plea and sentencing agreement form?
Yes, sir.
You understand the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs
No,
that
sir.
prevents you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the plea, or admission is freely and voluntarily entered. Court accepts it, adjudicates you guilty, reinstate probation, original terms and conditions, modifying to include 36 months Department of Corrections suspended, enter and complete an intensive outpatient rehabilitation program, $200 cost of prosecution, $250 PD fee.
Thank you, Judge.
Adjudicated, guilty. Okay, thank you.
Your Honor, currently we don't have our bridgeway doesn't offer intensive outpatient supervision.
You say outpatient or inpatient? It doesn't
Said
offer.
outpatient.
So Bridgeway does not have an intensive outpatient program?
Not here, no, they quit doing it.
Not here.
Now, we'll send him to get treatment.
Well, okay.
Different case.
It doesn't have to be Bridgeway, I don't guess.
Oh, now he's saying he's wanting to go to Alabama. If that's the case, now we open a whole other can of worms because he's gonna have to pay $100 before he leaves. He's not a resident of Alabama, I know him, he lives in here, Baker, Fort Walton, so y'all may wanna revisit that one.
Well, I thought they had a deal.
Best friends don't count as
Judge, it also turns out that he has two separate prosecutors. Ms. Berrickman's not here today. Ms. Bosso's covering for her.
Right.
I think there might be an issue with that.
I'm going to vacate the plea.
Okay.
Your Honor, if we could maybe address them later in the docket, we might be able to sort it out and still take care of it today if that's not a problem for the jail.
I have no objection to that.
All
Judge.
right, then I won't vacate it yet.
Okay.
We'll just hold him and bring him back later today.
We may
Yeah,
modify it.
1:30.
We'll see if we can work something.
Okay, all right.
Thank you, Judge. We'll bring it back this afternoon.
All right.
Your Honor, Tim Gibbs on behalf of Kelvin Brown, 22 CF 1420, 22 CF 1823. Judge, I'd like to put him for September 26th. We're also looking into inpatient programs for Mr. Brown. I think we
All
can
right,
get that resolved by
September
then.
26th. Thank you, sir.
Thank you, Judge. Your Honor, Tim Gibbs on behalf of Samuel Dwayne Catrett. This is 22 CF 61. Judge, I believe we've reached an agreement. I just need him to review and sign his written plea.
Mr. Gibbs, did you include the cost of transportation?
We can announce it on the record. I
Okay.
have no objection to that.
Okay.
Today's date. If I may approach, Judge.
Are you Samuel Catrett? Is that right,
Yes.
sir?
Yes, sir.
This is State of Florida versus Samuel Catrett, 22 CF 61. Mr. Catrett, would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God?
Yes, sir.
You want to admit that you violated probation?
Yes, sir.
Did you read and sign this plea and plea and sentencing agreement form?
Yes, sir.
You understand the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission?
No, sir.
You happy with the work Mr. Gibbs has done for you on the case?
Yes, sir. Yes, sir. Good.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Court finds the admission freely and voluntarily entered. Court accepts it, adjudicates you guilty, revoke and terminate probation. Sends you to 30 days Okaloosa County Jail, $100 cost of prosecution, $150 PD fee, due within 180 days of release. Credit for time served.
Thank you, Judge. There was also a $315.91 cost of transportation. We have no objection to that being imposed as well, and including that in the 180 days time frame for him to pay.
How much was it?
$315.91, Judge.
To who?
The Sheriff's Office.
Okay.
Mr. Gibbs, the score sheet.
Score sheet as well, Judge.
Okay. All right, thank you, sir.
Your Honor, Tim Gibbs on behalf of Thomas Chesser. This is 22 CF 3100. Judge, I had earlier believed that I may have a conflict of interest. However, we've resolved that issue based on some prior representation. I'd like to go ahead and just enter a denial for today's purposes and set him for September, let's set him for next week, September 7th, to give me an opportunity to speak with him about his case and see what we can try to do to try to resolve it.
Okay, this is Mr. Chesser?
Yes, Your Honor.
All right, September 7th.
Your Honor, Tim Gibbs on behalf of Clenny Davis. Right here, sir. This is 09 CF 266. We were trying to see what the recommendation from his probation officer in Leon County was. I don't know if we got that confirmation. Was probation able to get that confirmed at all?
Your Honor, it was, the violation is for a positive marijuana test. Methamphetamine test, I'm sorry. We couldn't get in touch with him. If you want to pass him, I can continue trying to get in touch with him. How long does he have? He's on till 2031.
So kind of the history of the case too, Judge. He was sentenced to 15 years DOC on this case with a 15-year DOC cap. Based on the score sheet we've been provided, he scores about 54.6 months right now. So I'm happy to bring him back this afternoon if we can try to confirm with his probation officer there what probation's recommending to try to resolve this case today, either whether that's some kind of time served situation or putting him back on probation so he can get back to Leon County.
If it's due to terminate in 2031,
Right, we can reinstate him.
I will not do credit for time served. I will agree to reinstate him with the same conditions.
You want to do that? Judge, I think we have an agreement.
All right, and it is Clenny Davis.
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for us courts of truth, so help you God?
I do.
And this is this 2009 CF 266?
Yes, Judge.
You, Mr. Davis, you want to admit that you violated probation?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission?
No,
Are you happy with the work Mr. Gibbs has done for you on your
I am.
case? The court finds the admission freely and voluntarily entered. Court accepts it. Will, reinstate probation, original terms and conditions?
That's fine, Judge. Thank you.
Okay, thank you.
And then the fees that we have to assess, the $100 cost of prosecution and the DPD fee, Judge.
Yeah, assess those fees.
Thank you, Judge. So you might want to talk to them first, and then they'll try to get you back over there. Your Honor, Tim Gibbs on behalf of Akeem Dixon. This is 18 CF 2695, 19 CF 562, 19 CF 1659, 19 CF 1660, 20 CF 835, and 22 CF 1506. If I could have just a brief moment with the state. Judge, we've been trying to resolve this case with negotiations with the state. At this point, I don't think that we've reached that negotiations. I'm not sure if Mr. Dixon wants to plead to the court to try to have the court resolve that, or if we otherwise need to set this for an evidentiary hearing for a VOP trial.
No, I'll speak to Mr. Gunter. Mr. Gunter, may I speak to you, Your Honor?
It's Judge.
Oh, Judge Gunter, may I speak to you?
Ask your attorney.
At this point, he's not going to be able to, he's not. Judge, I think he just wants to enter admission to the bench. I'm happy to go to sentencing today or if the court requires that we go to sentencing at a later date for both sides to present their argument.
If he wants to enter admission, fine, and I'll let set sentencing. How about that, Miss? Set sentencing at a later date?
As the court
And
prefers,
y'all
Your
can
Honor. I don't-
make your whatever arguments you want to make.
I have no objection either way.
Judge, Your Honor, I'm trying to resolve this today. I've been dealing with this since 2018. All I'm trying to do, Your Honor, they had 24 months on the table for me, and I said I'll take that. I'm just asking for I came in here with a tech. All I'm asking for is my credit from last year ran with this time, and that's 12 months. That's all I'll sign the deal and get up out of here. That's all I'm asking for, but she's trying to get me to sign just.
Okay, hang on a second.
Your Honor, I will be agreeable to this defendant to have all his credit for the time he served for he scored 60 months.
60?
60 minimum guidelines. And I'm willing to give him all the credit he's entitled to.
All right, how about that? I mean, I
Judge,
don't
the
want to get
effective credit
involved.
that he has
I
right
want
now
24.
is about a year. The effective credit that he has right now, Judge, is about a year.
That's their offer. I mean, I can't get involved in the negotiations, but I'm inclined to impose that if that's what you take.
Understood, Judge.
60 months, credit for time served, full credit for time served.
Full, whatever he's entitled to, yes, sir.
And there was an offer for a downward
It was
departure for 36 months with credit for all time served, or 24 months if he does just his VOP credit.
I didn't catch no new charge, Your Honor. I'm willing to sign that 24, and I'm willing to take. I'm just asking for my credit for time served.
Bring him back this afternoon, you can talk to Ms. Leo and get it straightened out, or
Yes,
figured
sir.
out. I mean,
Very
Well,
Judge.
no, Your Honor, I'm not going to change my offer. He decided to plead to the
I'm
bench,
just-
and I'm giving him all the credit that he wants.
You
Yes,
She offered
he
me
violated
20
probation
hold on.
4 times, and he's on probation on 5 cases. He's been given many chances, obviously, every time he was put back on probation.
And all I'm asking for is my credit for time served. I didn't catch no new charge. I came here on a tech. I'm willing to take these 24 to get up out of here.
That's not on the, that's gone. That offer is not there anymore.
No, it doesn't sound like there's a deal, so we'll have to set him for a trial, or y'all can negotiate the plea, or, I mean, something, or, I mean, she says it's a minimum 60 months. She said that's a minimum mandatory or a minimum requirement. Isn't it minimum mandatory, and he
Minimum.
served how many months already?
That's the presumptive prison sentence, Judge, based on his score sheet.
Presumptive is 60 months. He served, what, a year or two?
So on his most recent case, Judge, he was in jail from June of last year to April of this year. He's now been in on this violation for about a month, or about 2 months, I'm sorry, for a little over 2 months. So effectively, the credit that he has now is a year. Ms.
It's not
Leon,
minimum
of course,
mandatory,
doesn't
is
have
it?
to make an offer. She's offering
No.
to.
It's not a minimum mandatory prison sentence, is it?
No, there's not a minimum mandatory involved, Judge.
I may be agreeable to the guidelines, concurrent and coterminous, and all credit for time served.
Let's bring him back so I can
Yeah,
kind of
bring him.
calculate that.
I want him to understand what his option is. Y'all seem like you're changing things at every
Thank
moment.
you.
So bring him back at 1:30.
Thank you, Judge.
Is that on Asian time up there?
I'm not sure.
Right, look at that and say, boy, we've gone fast today.
It's been the longest 3:30 for a while there, Judge.
Bring him back at 1:30 so,
Thank you, Judge.
so Mr. Dixon knows what's up.
I'm going to calculate that. I'm going to come talk to you before we come back to court. Yeah. Probably. If you're going to, until I can come talk to you, so we can bring you out. All right.
Y'all don't put me in these I'm not going to get in the middle of these negotiations.
Actually, Judge, if we could approach on that.
Who is this gentleman?
This is Mr. English, but I'd like to approach on Mr. Dixon.
Oh.
Yes, Judge. In English, these are case numbers. It's 21 CF 2151, 22 CF 3185, 23 CF 739. Judge, I believe we have an agreement. He just needs to sign his written plea. So again, like I showed you. So if that's what you want to do, I need you to put that right there for me, please. If I can approach, Judge.
All right, sir, you're Justin English?
Yes, sir.
All right, this is State of Florida versus Justin English. 21 CF 2151, 22 CF 3185, 23 CF 739. Mr. English, would you please raise your right hand to be sworn? You swear the testimony you give for this court is the truth, so help you God?
Yes, sir.
You want to admit that you violated probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir, I have.
You can put your hand down. You understand the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission? Are you under the influence of any medication or drugs that prevents you from knowing what you're doing here today?
No.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, I have.
Court finds admission freely and voluntarily entered. Court accepts it. On 22 CF 3185, count 3, the court is going to revoke and terminate probation, sends you to 60 days Okaloosa County Jail, credit from VOP arrest only, date. All other cases and counts, revoke and terminate probation, 6 months Okaloosa County Jail concurrent, credit from VOP arrest only, total $300 cost of prosecution, $350 PD fee, due within 180 days of release, adjudicated guilty, all cases, all counts.
Judge, I have a score sheet without objection. It is a downward departure, legitimate.
All right.
Sentence you to 6 months. Seems off. Just write me. Start working on it, okay? Your Honor, this is Elizabeth Graham, 22 CF 2264, 22 CF 570. Judge Tim Gibbs on her behalf. Judge, we're working on potentially getting her into drug court. I'd like to just go ahead and set her for next Thursday, the 7th at 9 a.m. To see if we can.
All right, September 7th.
Thank you, Judge.
Thank you.
Yeah. Thank you. Thanks. I think so.
Your Honor,
Morning.
this is William Peage on 22 CF 3095. I filed a motion with the court asking the court to consider correcting jail credit. He was sentenced on approximately 5 cases. He got credit on all his cases, but on this particular case, there was a signature bond that was signed back on January 26th, but he never got out of jail. He had been in jail he was in jail December 10th, then returned to jail on January 7th of this year, and he remained in jail till his sentencing date he went, I'm sorry?
I'm sorry, the 23rd of May.
That's what I was about to say.
Oh, I'm sorry.
All right. So let me just start over, Your Honor. On August 10th, he was sentenced to 11 months and 29 days on all his cases. And on this particular case, he had signed a signature bond, but he remained in jail. He never got out of jail. and he signed the signature bond on January 26th, but had never left the jail. So even though he has been in jail since January 7th, 2023, was sentenced on April 24th, 2023, the jail, of course, didn't give him that credit. They gave him the credit on the other cases because it didn't show a signature bond. It looks like it's around 107 days, so it's added approximately 107 days to his sentence. That was not anticipated.
I don't see a motion, Mr. Rivers, so if you want to file that just for clarification, I'm fine with that, Judge. It's not a benchmark, so.
Well, send me an order with a stipulation for
Yeah,
this.
that's fine. It was my understanding that he was in jail the entire time. As you see, he did sign out a signature bond, so I'm fine with the stipulation of giving him that credit from his original date of arrest for this case.
Send
I just don't
send
see
me an
anything in
order,
the
Ms. Rivers. Okay.
Uh-huh.
Everything's good, so,
Nope, not by tonight.
but whenever they do it.
Mm-hmm.
Okay, but everything's good.
Mm-hmm.
Okay, thank you. You're awesome, thank you.
Okay.
Saying you thought about your own case.
22 CF309. Your Honor, before the court is Rusty Rogers on 22 CF 60. He is here on a violation of probation. And, Your Honor, he also has set for this afternoon a count of burglary of an occupied conveyance. So for this morning's case number, we are going to enter a denial. For this afternoon's case number 23 CF 1681, we're going to enter a not guilty plea and request trial by jury. And I ask that all cases track together, so it would be on the October 30th docket.
The state has no objection.
All right. Track them together October 30th. Thank you, sir.
I'll be out there to talk to you about it. No, you won't be back this afternoon. Mm-hmm. 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 Your Honor, before the court is Tequacia Rodriguez. She is before the court on 22 CF 92 and 22 CF 743. Your Honor, an evaluation was conducted on her, and it was filed with the courts, and I'm not sure if the court has had an opportunity to read it yet.
Yep.
And she does have some paperwork that she did want me to provide to the court, and I would just recommend that we do it at a later time. And I did speak with her about how I felt the recommendation would come back as being not competent. So at this time, they are saying that she is not competent and requesting that she receive treatment. So we would need a finding again of incompetence and...
Department of Children and Family Services.
Yes, sir.
Your Honor, the state has no objection to the court considering the report, and we recommend that the court follow the recommendation of committing her to the Department of Children and Families for competency restoration.
Retrial. Okay. Thank you. I will read.
Thank you.
All right.
Receive a copy of that?
Yes. I will.
The court adopts the recommendations of the report and finds her incompetent, committed to Department of Children and Family Services. Thank you.
And we'll submit an order. Did you get an opportunity to look at it? So, Your Honor, I would ask, Ms. Sanders was just made an offer, and I would ask if we could put her on for this afternoon.
All right.
Okay.
1:30.
Your Honor, this is Julius Sledge. He's before the court on 22 CF 2218 and 23 CF 1017. Your Honor, at this time, we are going to enter denials and request that this case be set out a month, maybe. He has asked me to file a motion for bond hearing, and I will try to get that put on for next week.
What, September 7th?
Yes, sir.
Okay.
When was it?
September 7th for a bond hearing.
You want to set his VOP date now?
Yes, Your Honor. Or we could just wait till the 7th, either way.
What is the next hearing date? October 26th?
The 26th, and then November 2nd.
October 26th.
All right, thank you, Your Honor.
Thank you.
Yes, sir.
Your Honor, before the court is Richard South. We are here on our motion for a bond hearing, and originally, when I had filed for this, I was asking the court to modify the first appearance findings. The state has subsequently filed an information, which I believe takes care of part of that problem. He was originally given a bond for murder, even though it was alleged that it was attempted. The state has ultimately filed attempted first-degree premeditated murder with a weapon, burglary of a dwelling while armed with explosives, and aggravated battery with a deadly weapon. I show that he has a $10,000 cash professional bond on count 3. He does need bonds on counts 1 and 2. I am asking the court to consider a signature bond. Mr. South is 69 years old. He is on Social Security. He's the sole supporter of his family. He lives in public housing. He has a grown kid with disability. And I was able to review his CCIS history, and he has no history of violence whatsoever.
Your Honor, this was an arrest by Crestview Police Department. I've spoken with them. It's standard. Their statute box, whenever they're filling out their arrest report, they can only put one statute per count. So they're not able to put the 777.04 for attempted, but it does mention attempted murder all throughout the arrest report. The state has filed charges on attempted first-degree premeditated murder with a weapon for count 1, which is a live felony, which means the court can hold the defendant with no bond. He's currently on no bond with count 1 anyways. Count 2, the state filed burglary of a dwelling while armed with explosives or a dangerous weapon. The state for that count would be requesting a $20,000 bond, and count 3 is aggravated battery with a deadly weapon. The state would request $10,000 bond on that count. In this case, Judge, according to the first appearance paperwork, Pretrial Services has noted that the defendant currently is wanted out of Trenton, Ohio. In this case, the defendant and the victim had gotten into an argument earlier in the day because the victim confronted him about the defendant owed the victim some money, and the victim actually left the defendant. I guess they rode together to the gas station. The victim left the defendant at the gas station, which in turn made the defendant angry. So the defendant and his son go to the victim's house. The defendant's son knocks on the door, and the victim looks through the peephole and sees the son of the defendant, so he opens the door. And then the defendant...
Well, he's wanted out in another state also?
That's according to the first appearance paperwork, Your Honor. I was just looking at that.
Your Honor, there's an indication from him that it's for a fine?
Unpaid fine. That's all it is. It's an unpaid fine.
Worried we won't get him back if...
$100.
Okay, I didn't mean it. Go ahead. Finish.
Yes, Your Honor. So the defendant, while on the victim's front porch, he came to the victim's house. The victim opened the door because he thought he was opening the door for the defendant's son. The defendant jumped out and he stabbed the victim not once in the abdomen, but twice. And when he stabbed him the second time, he actually left the knife in the victim's stomach and he fled. And when law enforcement made contact with him, he denied stabbing the victim, but he had blood drops.
No bond at this time, count one, and $20,000 cash for professional, count two, $10,000 cash for professional, count three. Thank you.
It didn't change.
That's wrong now.
Your Honor, we've reached an agreement in this matter. This is Russell Wayne Thomas, 22 CF 776, if I may approach.
All right.
May I approach with the score sheet, Your Honor?
You're Russell Wayne Thomas.
Yes, sir.
This is State of Florida versus Russell Wayne Thomas, 22 CF 776. Would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God? You swear to tell the truth?
Yes, sir.
You want to admit that you violated probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir, I did.
Are you aware of the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you, threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers has done for you on your case?
Absolutely. Yes, sir.
Court finds the admission freely and voluntarily entering. Court accepts it, adjudicates you guilty. 30 days Okaloosa County Jail. Credit for time served from the violation of probation arrest August 7th, 2023. Reinstate probation, convert remainder to community control. All remaining original terms and conditions are to be completed. Waive cost of supervision. $100 cost of prosecution, $150 PD fee.
Yes,
Thank
sir.
you.
Right there.
All right, thank you, Mr. Walker.
Your Honor, he has more than 2 years on remaining, so if you can reinstate him with the next 2 years on community control, he would still come off community control and have a little bit of probation.
No objection.
Court will do that. Reinstating community control. Correct.
Followed by the remaining period on probation.
The remaining period on regular probation.
Your Honor, this is Tina Sue Warrington before the court on 23 CF 1139. A mental health evaluation was done in this case. There was a recommendation that she was incompetent, that she needed to go to Florida State Hospital for treatment. However, Ms. Warrington wants the court to know that she believes that she does not need to take medication and that she wants to accept the state's plea agreement. And that's where we're at right now, Your Honor.
What does the state say?
If she's been deemed incompetent.
She hasn't been deemed incompetent, but
She
it
has
is.
not?
She has not been found incompetent, Your Honor. A mental health evaluation has been done, and it is the recommendation of the mental health provider that she be found incompetent, that she be sent to Florida State Hospital for treatment.
You're going to be here this afternoon. I'm trying to remember. I read so many of these recommendations.
I didn't sign my plea deal.
I have a copy of it right here.
All right.
Let him know that. It's not right.
Trying to keep her.
She had signed a plea agreement, willing to take it, but this.
2 months before this came about, and it's not right.
I told her.
I don't need medication. It's not right, Lisa. You know it. You know it.
was this filed? Because I don't remember reading this report. When was this filed? Was it sent? I don't remember reading this one. It's rather short.
It would have been last week, Your Honor. I had asked my assistant when we got out of court on Monday about filing it, and she had indicated that she had already filed it the week prior.
What does the state say?
Your Honor, the state had made an offer of credit time served prior to the evaluation being done.
Well, it says that she understands the adversary nature of the process is acceptable.
And she does.
Yeah.
She is able to communicate about
Give me the plea.
that. I'm sorry?
Let me have the plea form.
Yep.
That's what she wants to do.
Yes.
Ms. Warrington, would you please raise your right hand and be sworn?
Yeah.
You swear the testimony you give for is course of truth, so help you God?
Yes.
Okay. Gotta wait for the plea form here. Ms. Rivers, here's this.
Yes.
All right, this is 23 CF 1139, State of Florida versus Tina Sue Warrington. Ms. Warrington, you want to enter a no contest plea, the charge of battery on an inmate, a third-degree felony? You want to enter a no contest plea?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yeah.
Did you read and sign this plea and sentencing agreement form?
Yeah.
You want to force you or threaten you to enter this plea?
No.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No.
Are you happy with the work Ms. Rivers done for you on your case?
Yeah.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judges you guilty, sentence you to credit for time served, $967 court costs, $100 cost of prosecution, $150 PD fee, and adjudicated guilty. That's it, correct? Okay, thank you.
All right, thank you.
Stay out of trouble. That's also a part of my sentence. All right.
Your Honor, the next one on the docket is Vernon Webb.
How many more inmates we got back there for this morning?
Ms. Rivers has 2 more, and then Mr. Williams has...
I have 5, Judge.
6.
We did Mobley.
After this, we got to take a break because I got a bunch of search warrants and other. I'm duty judge. I got to do those.
Your Honor, we've reached agreement in this matter, if I may correct?
All right. This is Vernon Webb.
Yes, it is, Your Honor.
Mr. Webb, would you please raise your right hand and be sworn? You swear the testimony you give for is course of truth, so help you God?
Absolutely.
This is State of Florida versus Vernon Brent Webb, 22 CF 2054 and 22 CF 2749. You want to admit that you violated your probation?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You aware of the rights you're waiving by entering this admission?
Yes, sir.
Anyone force you or threaten you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers done for you on your case?
Absolutely.
Court finds the admission freely and voluntarily entered. Court accepts it. Judge you guilty on both cases. Sentenced to 90 days Okaloosa County Jail, credit for time served since the violation of probation arrest on June 20th, 2023. Reinstate probation on the same terms and conditions, $100 cost of prosecution, $150 PD fee. Continue to waive cost of supervision. On 22 CF 2749, credit for time served. Reinstate.
Your Honor, the only difference between the first case and the second case was the date that they submitted the VOP and the date that he got arrested. It was actually more than a month later. So that's why it says credit time served on the second case versus the 90 days that on the first case.
With probation with the same terms and conditions, $100 cost of prosecution, $100 PD fee, waive cost of supervision, $1 a day for
Ankle monitor.
Ankle monitor. And that is credit for time served, whereas that's what I was wondering about. The other one is 90 days, Okaloosa County Jail from that date, June 20th. Okay? Okay, thank you.
Your Honor,
Take care.
He's to remain at Okaloosa County Jail until he is hooked up on the GPS monitor, please.
All right.
That's not today, right? It's Monday, or how do I know what day?
He'll talk to you. He'll help you.
Yes.
Let's take, I've got to
Break.
do some warrants. So we'll take about a 20-minute break.
Yes, sir.
All right.